I think there's nobody in this room, whatever your political small p bent is, that wouldn't agree with the statement that somebody being improperly, wrongly incarcerated is like one of the worst things our society can do. I mean, let's all agree on that premise. But analyzing circumstances that arise in the 80s or so is different than what we run into today, which we would consider prosecutorial misconduct. I think it has changed because of a change in the culture, a change in the criminal rules, a change in a lot of things.
We're very happy to have you here tonight. An important conversation that's about to happen on prosecutorial misconduct. We're going to hear from a distinguished panel of experts. It's all going to be moderated by Brooke Williams. This is part of our newest series. It's called Boston Talks Investigates, and that's what tonight is all about.
A little bit about our center, the New England Center for Investigative Reporting, which launched in 2009. We're a nonprofit news outlet based here, as Phil said, at WGBH, affiliated with Boston University. Two main missions: one, to do in-depth investigative reporting that has impact, and secondly, to train a new generation of investigative reporters. Since our launch, we've done about 150 stories that have won national and local awards. Our stories are seen around the region and across the country. You listen to them here on WGBH. You'll see them in the New York Times on occasion, Washington Post, CNN, NBC, various outlets across the region, across the country, as I mentioned. And as far as our training goes, we've trained about 600 students, journalists, and citizen journalists, actually, over the past 7 or 8 years from all over the world. And that is part of our goal, to make sure that in the coming decades, there will be other investigative reporters to do the kind of work that we're doing now for years and years to come.
Prosecutorial misconduct, it's a mouthful, right? So what are we talking about here? Judge Ball, would you like to start?
Well, I don't know whether you want me to spin off. I've read your first column, of course. Sean sent it to me. The things you seem to be focusing on are failure to provide discovery, or lack of discovery, A, and B, excessive improper closing argument. So I don't know if you want to limit the discussion to those two things, but they are fertile ground for discussion. So that's the answer to your question about the definition of right? Am I wrong?
Yeah, so is this prosecutors breaking rules, bending rules, laws? What?
Well, my take on it is that we need to look at the situation by decade, okay? So it's not surprising to me that a lot of the cases, the Ulysses Charles case, for example, that, or Ulysses Charles, that many of the cases that are now front and center of prosecutorial misconduct, a lot of the DNA cases, are all that have resulted in the Innocence Project and so on, are all cases that were tried in the 70s and 80s and so on. And I do think that a review of the cases that are now high profile have to be seen in the context of those times, which doesn't, I mean, I think there's nobody in this room, whatever your political small p bent is, that wouldn't agree with the statement that somebody being improperly, wrongly incarcerated is like one of the worst things our society can do. I mean, let's all agree on that premise. But analyzing circumstances that arise in the 80s or so is different than what we run into today, which we would consider prosecutorial misconduct. I think it has changed because of a change in the culture, a change in the criminal rules, a change in a lot of things. So,
Thank you.
I would broaden it a little bit from that, because I think in talking about prosecutorial misconduct, going back to your initial question, I think we're talking about prosecutors doing things wrong. And I think it covers a broad array of prosecutors doing things wrong. So some of it is prosecutorial mistakes, and it can range from an error that comes from lack of preparation or lack of experience to intentional wrongdoing. So I think the conduct falls across a broad spectrum. And I think that's why, with regard to some of the lack of sanctions, and I know that's an issue that you talk about in the article, but I think some of it results from that spectrum of allegations and where along that spectrum the conduct falls that's being complained of.
Okay.
To you, from the defense attorney perspective.
I think prosecutorial misconduct involves the withholding of exculpatory evidence, failure to disclose evidence despite a defendant's specific request for information, and also a continuing failure to disclose exculpatory information after an individual has been convicted, especially where an individual has been convicted and goes through appeal after motion for a new trial after motion for a new trial, and the issues are written on the wall, and prosecution teams, they have evidence that will help this person, but they don't turn it over. Why?
So we've talked about what is prosecutorial misconduct. So we have a general understanding. So let's get into some more details here. Our review of more than 1,000 cases found judges reversed 120 convictions, in part or entirely due to prosecutorial misconduct. I'd like to hear what each of you thought about this finding. Let's start with you, Veronica.
I find it disturbing that there are situations where prosecution advocates have access to evidence that will help a criminal defendant, evidence that's exculpatory, and that they choose to withhold it, and that a person can then spend decades in prison fighting for his freedom.
And we also found there were only 2 instances in which a prosecutor had been publicly reprimanded in the history of the Board of Bar Overseers, which is the entity established to monitor prosecutors' actions. What did you think about that number?
I think it's very low, and I think where prosecutor is the most powerful person in the courtroom, really should have a independent body that implements some review of the files, that has access to the materials that the prosecution has. There has to be a body to review what they do, because otherwise they're policing themselves, and that's not enough.
Thank you. Judge Ball, what did you think about the findings?
Sort of hearkening back to my last statement, I wasn't surprised though obviously appalled, I wasn't surprised at the results because, as I say, back in the day, when I graduated from law school in '76 and went into the business, I tried one of my first jury trials with Diane, who was a public defender at the time. Remember, you handed me my lunch? Yeah, I forgot to put in the foot on the shod foot. The foot, and what did he have on his foot in November? A shoe. That's an element of the crime. Anyway, in those days, it was the end of an era of sort of wild, wild west trial work. And people came in and took a case file and tried it without preparation. Everybody was, it was all about it was like today's TV watching, which your closing arguments are dramatic stuff, which isn't what it's supposed to be. So there was like error left, right, and center in terms of excesses in closing argument. There was lack of preparation that is what you need to make sure you've turned over all the discovery to defense counsel. And it was just, when I read old transcripts, I just wince at what was going on in those days. So I'm not at all surprised. What I am hopeful about is the changes since those days, such as the change in the rules of criminal procedure, which have codified the obligation to turn over exculpatory evidence. Open file discovery is the goal. I'm not saying it's been achieved, but it's a heck of a lot better than it was in the 70s. And frankly, it's better than it is in the federal court but I'll leave that for another day. That in addition, there became a culture. When I first really got to know Diane well, the Middlesex DA's office, Scott Harshbarger came and was the DA. And with him, and Diane, you were first assistant, they started a training program. DAs were never trained. When I first came out, the DAs had a private practice in the afternoon, making money doing civil work, and they were trying cases in the morning on the fly. Nobody ever trained anybody. And in the late 70s and early 80s, you started having training programs, which people like Diane were teaching, Jay Carney, and people who had gotten taught anyway. And you learned about how to try a case properly and what is proper argument, and how important it is not to win a case, but the goal is to do justice. And that's what needs to be taught. I am hopeful that the kind of things that you guys have recorded will happen a lot less frequently now. I'm not saying there aren't problems. I mean, I sat there and Veronica and I worked together in Suffolk Superior Court all the time. There are ongoing problems with the Boston Police Department, being careful and about turning over all their reports, so the DA who has to produce them to Veronica, when he says, I've got everything here, and he really does have everything. Computerization is happening that. It used to be that, the street detectives who first responded to the homicide are writing a report that the homicide detectives who come on a couple hours later on the scene never knew about. So the people who end up being the interface with the DA, the homicide detectives, don't even realize that Joe Schmo, the patrolman, has a report that never got turned into the file. But now with more computers, that kind of stuff should be better. I'm talking too much, I know, so you definitely can stop me and I won't be mad. But now it's necessary, and a good ADA, and there's training in DA's offices now. I see people here from the Suffolk DA's office. They're training DAs, and hopefully they get the message that you can't just say, call the cop. Detective, you got all the reports? Yeah. You got to go to the police department. I mean, other counties other than Suffolk are less good about this, but you got to sit down with okay, let me see your file. Okay, cop, open the file here. You're detective, I want to see your file, and let me compare it to what I have, and do it report by report by report to make sure you have everything. Again, hopefully computerization will help that kind of stuff. But as I say, I do think that as appalling as the stuff you uncovered, along with the rise of DNA testing and stuff, we're in a different landscape now. Not, hopefully a better landscape, not a perfect landscape. And if there's negligence, as Diane mentioned it, sort of misfeasance rather than malfeasance, it can work just as bad in injustice. But I do think it's a different world now than it was then.
Okay. Before we move on to Diane, I just wanted to point out, you mentioned briefly, what is a win in a district attorney's office, right?
Yep. Or defense counsel, for that matter. I mean, there is a gladiator
Right.
aspect to this business.
Absolutely. And you mentioned it's justice.
That's what it should be. And I think any good trial lawyer, criminal defense or prosecution, should know that in their heads. That what we're after here is doing justice. And judges, too, should know that as well, not moving cases and getting stats and reducing your case, but it should be by doing justice in the individual case. But you have to keep reminding yourself of that, because as human nature, you want to win that case. You want to get your guy off. I remember my first murder NG was like, yes! But I also remember my first murder guilty as a DA. That's human nature. But you got to keep reminding yourself, and the people who are head of your office have to keep reminding you and training you that it's about doing it the right way.
I think we're very much outnumbered. As defense attorneys, the onus is on us to file the motions for specific requests of exculpatory evidence. Think of everything that we can think of under the sun that could exist in this case. And when the prosecutor turns evidence over, say, no, this is not enough. This is not what I believe you have, and I'm filing this request and this request so that you can go look for some more. Simply not taking the answers for its face value. And I feel like we're very much outnumbered. We're dealing in a situation where everybody's against us. The police are against us, and prosecutors, and sometimes even the judges. And it can be very overwhelming. I wish that there were more measures in place so the onus didn't have to be on us.
And to go back to your question about what do we think about the findings, a couple of thoughts, a couple of things I'd like to mention. One is, lurking out there is the scary issue of how many things aren't uncovered. Going to Veronica's point about the disclosure of exculpatory evidence, or evidence that would be helpful to the defendant, that would tend to either undercut the state's case or even mitigate punishment. So the cases that you see, and my guess is that it's a relatively small subset of the cases you found on prosecutorial misconduct where cases were reversed that actually focused on a failure to disclose exculpatory evidence. My guess is that more of them were in the closing argument area or a combination of errors made during the course of a trial during which mistakes in closing argument, overzealousness were part of it. But there is a universe of cases that might never be discovered. That is, you might not know that there is evidence that's helpful to the defendant out there. And that comes up in two ways. One is the police may never recover it. It may be if there were other witnesses to a crime. If their names aren't gathered at the time the police report to the scene, they may be lost forever. So some of it goes way back to enforcement on the street. And then there is the issue of ensuring that prosecutors get everything the police do have, and then the further issue of making sure that prosecutors turn over everything that may be considered helpful to the defense. And in there, there's also a risk, we all see things from our own perspective, so there's also a risk that prosecutors aren't going to recognize something as what we would call exculpatory or helpful to the defense, even though it's in the file. Whereas defense counsel may know that this is going to be valuable to you, that you'd be able to use this during trial. The prosecutor may not see it as that because we're coming from different directions. But I think the idea of a wrongful conviction should, and I think does, horrify any ethical prosecutor. And I think there's a risk of wrongful convictions even when we do everything right, even when we do the best we can do, because it's a human system. It's not ever going to be a perfect system. But I think the things that we need to be seeking, that prosecutors need to be seeking, are ensuring that innocent people, doing what we can do to make sure innocent people aren't convicted. So that truth-finding function. Ensuring that defendants are accorded procedural justice, that there's fairness in the system, and also ensuring that defendants are treated equitably, that similarly situated people are treated fairly among themselves. So it, again, the findings are troubling. We would all, I think, wish that we could do our jobs perfectly. And there are some outliers. There's no question. The cases we tend to read about in the media tend to be this small number of extraordinarily mishandled cases, and cases where prosecutors are found who have done, truly unethical or unconstitutional things. And whether something's unethical or unconstitutional, those are actually different judgments that may or may not overlap. And then it gets to, what can we do about it to try to at least to prevent or minimize the occasions in which that occurs.
Mm-hmm. Yeah, I hope he's in the audience tonight. I received an email in response to this story describing the distinction between a wrongful conviction and an unlawful conviction. And I thought that was an interesting concept. Many of the cases that we read, the judges determined the prosecutor, there was some sort of misconduct or error, but called it harmless error.
And I would say I think that's a distinction, too, between misconduct and error, or at least in the way we tend to think about those terms. Misconduct seems more knowing and intentional, and error can be a mistake, and it can be a mistake that has significant consequences. This matters. People, serve time in prison that they shouldn't serve. There's a loss of reputation, there's embarrassment to their families, their financial consequences, their psychological consequences. I mean, they're for any wrongful conviction. But there may be, in fact, convictions that are the result of error that isn't misconduct in the way that I think of misconduct. That is, conduct that should be punishable either through action by the attorney disciplinary authorities, or obviously you're seeing overturning of a conviction. I mean, there are a limited number of remedies available, but quite a limited number.
Thanks. So Veronica, before I move on to the opinions in which judges reverse convictions and why those opinions almost always do not name prosecutors, I wanted to ask you about, as a defense attorney, you ask the prosecution for all exculpatory evidence. Do you have to say, I want this particular file? How does that work? Do you sometimes resort to the Freedom of Information Act? I mean, can you?
Yes, so we can use the Freedom of Information Act to obtain, post-conviction, an entire copy of the Commonwealth's file. And I've done this before, where I actually had the benefit of seeing notes and taking pictures and going in with a portable scanner and my investigator, who's actually here, and he brought his camera, and we took pictures of everything. And it was very helpful, and the things that I was able to document when I did that FOIA review changed the course of the case that I did. But it does help to make specific requests rather than a general request for exculpatory evidence, because if you make a specific request and the prosecution has that evidence and does not turn it over, then the defendant actually has a lesser standard to prove on post-conviction relief. There's also other things you can do with regard to a TUI request, which is a federal request for federal documents, and I've actually been very successful in getting federal documents that way that have helped people.
I do want to be clear that prosecutors do have an affirmative obligation, even without request, to turn over exculpatory evidence. And the ethical rules in Massachusetts were just changed and became effective this week, I think, Monday of this week, requiring that if prosecutors discover exculpatory evidence post-conviction, they also are required to turn it over.
So was this not happening before?
Well, I mean, there certainly were situations where prosecutors did that. You saw examples, I mean, I can think of several out of Suffolk County where exculpatory evidence was brought to prosecutors' attention, and they actually, joined with the defendant in going before the court and seeking and supporting a motion for a new trial and conviction being vacated. There's situations, many here may have heard about the situation with the drug lab and misconduct at the Hinton Drug Lab. And there were cases there where when it was first discovered by the prosecutors, they brought this to the attention of defense counsel. So
Post-conviction.
Post-conviction, yeah. So it's not, but it wasn't explicit the way it's explicit now. In fact, prosecutors have one specific rule that applies only to them in the Massachusetts ethical rules that apply to all lawyers. So we're covered by all the other rules, but there is one specific rule that relates to special responsibilities of a prosecutor. And that's the one that addresses, in terms of ethical rules, the duty to turn over exculpatory evidence, and now specifically references post-conviction discovery of exculpatory evidence. And this is in addition to a constitutional obligation to make exculpatory evidence available to a defendant, and other constitutional obligations that don't. A prosecutor here can violate an ethical rule without it necessarily resulting in a constitutional violation.
So now it's the law that a prosecutor, if they find evidence that might prove someone is innocent, they have to turn it over if the person's been convicted.
Broadly, yes. I can't quote the exact language to you because it's brand new, but it's explicit now. Whereas I think it would have been understood in large areas by prosecutors before, but I don't think that it was an ethical requirement.
Okay. All right, so moving on, a few judges name prosecutors who commit misconduct, even when it's severe enough to reverse a conviction. In some cases, they even redact their names. There have been judges who've dissented, saying, why aren't we naming this person? We're reversing a conviction. We're putting the family through this all over again. We're putting the defendant through this all over again. Why aren't we naming the prosecutor? Why aren't we naming prosecutors? Why aren't judges naming prosecutors?
I think it's cultural to some extent, because you'll notice in a lot of these opinions, there's ineffective assistance of counsel, and you don't name the defense attorney either, you know, and part of that is there is a culture of, I would say, civility is what you don't personalize this stuff, and just totally aside from the issue of wrongful convictions, in the civil world either, it's all very ritualized that you don't name names. And I will tell you right here and now, as a judge, I was talking to a friend of mine, to Chris McAvoy, about this panel, and we were both agreeing that while we had instances where we thought about reporting a lawyer to the Board of Bar Overseers, neither of us had ever done it. And I think I would have if I felt it was necessary to do that in the circumstances, but there is sort of a feeling you don't want to blow somebody's career out of the water if you think you can correct the problem another way, and that pervades the entire practice of law.
But I think that's a big issue, if you can correct the problem another way.
Right.
Because I do think that in cases of clear misconduct, and this isn't just the mistake, but clear misconduct, I do think there should be more reporting of all lawyers to the Board of Bar Overseers. I think the point Judge Ball makes that prosecutors can't appeal convictions. So if defense lawyers...
Acquittals. Or even convictions, you're
or
right.
even convictions.
Right, you're right.
Prosecutors can't appeal. So if a defense lawyer engaged in misconduct during the course of a trial, and I'm sure we could all give examples of that, there's not a mechanism by which an appellate court reviews that the way there is for prosecutors. So I think that in that case, the bar discipline authorities in Massachusetts, the Board of Bar Overseers, would be the sort of only mechanism for that being addressed. So I think there is a way in which the great common courtesy can allow true misconduct on the part of all lawyers to go on without being addressed because of that.
At the expense of people that do decades in prison. And unfortunately, people suffer, families suffer. People that are innocent stay in prison for years because prosecutors have not done their job, because judges are not reporting these people, because there's no independent authority that's reviewing their work, because essentially the prosecution, they're left to police themselves, and a lot of times, and we've seen evidence of the fact that there's just not enough here to implement the ethical rules, and people suffer. People suffer a long time.
You mean deterrence value, not
Yes.
so much punishment for the individual miscreant, but that to send a message to the rest of the culture that you can get referred if you don't mind your P's and Q's here.
Not you can, but you will. I mean, thank you. There has to be something in place here, because otherwise it's going to be a big free-for-all. And people are paying with their lives, with their freedom. They're being stripped away from their homes, their families. You think about somebody that's doing a life bid, 35 years in prison, and somebody who's been deprived of mountains of exculpatory evidence. Why? Why does it take the zealous work of one person who has to basically fight the whole system, take the whole system on? Why does that have to happen in order for justice to be done? Why can't we have
an independent body that actually makes sure that the most powerful attorney in the courtroom does his job.
I would say I wouldn't have a problem. For example, if you've got a prosecutor who repeatedly engages in a similar kind of misconduct, and and has been told this, an appellate court has said this is error, and the prosecutor repeats it. I don't have a problem with that person being named personally. And I do think there is more invisible action going on. That is, it's my understanding that the Board of Bar Overseers reviews appellate decisions, and that every time there is a finding in an appellate decision that a prosecutor engaged in misconduct, they send a letter to that prosecutor and ask for an explanation. One of the things that is interesting, and I'd like to know more about, because I know you said in the article that there were very few, two reported cases of public reprimand.
Right.
And
7 private.
And nothing that went farther than that. There's also their informal resolutions where they require training in certain areas, like what is proper closing argument and those kinds of things. But in cases of really egregious misconduct, there should be more. And there's no reason why that I know of, and I can't speak as an expert on bar discipline here, but there's no reason that I know of why the Board of Bar Overseers, in cases of egregious misconduct, they have authority over every lawyer in the Commonwealth, and why they can't do more. And prosecutors may feel, okay, well, we're more exposed because this is what gets appealed, this is what's on the record. But prosecutors also have great authority, they have great responsibility. They're actually the only lawyers in the Commonwealth that have an affirmative obligation to see that justice is done. Mm-hmm. Well, I mean, judges do too, but I'm talking about I know you do.
Yeah.
But I'm talking about in the litigation aspect. I mean, it's a heavy responsibility, and the potential consequences are severe. So it does seem as if, so it isn't that there's nothing in place. It may be that it's not being utilized to the extent that it can or should be. And I don't know the answer to that, and I hope you're going to be exploring it.
I think that there isn't anybody who would disagree that if a judge is aware that a prosecutor intentionally, knowingly, let's put it that way, knowingly withheld exculpatory evidence, that they should, that everybody would agree that person should be referred to the Board of Bar Overseers. But the vast majority of the time, it's that they didn't get the information from somebody. And they're the last person, so you're in the middle of a trial, and suddenly the cop is on the stand, and he's saying, as XYZ said, and the defense attorney's going, wait a second, I never got that in a police report. And you're at sidebar with the judge saying, Judge, I never been told this. And then you send the jury out, and the cop says, oh yeah, I put it in a report. And the DA says, I never got that report. I mean, it's often that situation. So so in that circumstance, does the DA get referred to the BBO? The DA should have somehow or rather been more careful about that. Maybe the DA was. Do you see what I'm trying to say? So it's not necessarily, I think we all agree in a black and white situation, BBO's in order. The question is where we are in the spectrum between malfeasance and negligence.
Well, you mentioned should be referred. Are they? In cases of
I know of several
knowingly.
circumstances. I know of a couple of circumstances where prosecutors were referred to the BBO. I've not heard, not necessarily in reversal situations, but I can recite a couple where they were referred.
Okay.
But admittedly, if it's a first-time referral, I mean, the BBO, the Board of Bar Overseers, has as Diane referenced, a range of punishments: private reprimand, public reprimand,
Right.
disbarment. So it can be resolved in other ways, and they are entitled to counsel. And if it's a one-time mistake, just like if you're a civil lawyer and you make some mistake, often the first offense is a private reprimand. So.
Right.
I think the problem I have is that there should be more done in the front end to prevent the withholding of exculpatory evidence. There should be more oversight. There should be an independent body that actually has access to prosecution's files and notes. And prosecutors should be able to, should keep a log of all the interviews that they have with witnesses, with police, with government authorities, and that log should be accessed by an independent body, and there should be reviews, and those reviews should be computerized and kept in writing, and they should be reviewed by judges. I don't see.
One thing Veronica said earlier is so true for defense counsel, and when I made the move from being a prosecutor to doing criminal defense work, you do feel as defense counsel that you're out there, it's you against the world. You representing your guy, and it's you against the world. Because you go from being a DA, and if you want to, you call up a cop, say, listen, will you go interview this witness? And the best investigator in the world, you send out to interview somebody, and they say, no, I don't want to talk to you. And you can't make them talk to you. So there is a feeling among the defense bar that there is some basis for that, like everybody's against me. And I know there must be more stuff out there, but I don't even know what it is. And how am I going to get it if I ask the prosecution for the materials and they tell me it doesn't exist? And you're like, and then it turns out years later, after your guy's been convicted and has done 15 years, it turns out there's this other stuff. So it's a difficult world, this world of doing criminal defense work and monitoring the issues that we're dealing with today.
I want to say, and it's something Judge Ball touched on briefly, I know the subject today is prosecutorial misconduct, but my students who are out working as student prosecutors in a number of DA's offices throughout the Commonwealth write reflective journals about their experiences. And over the course of the year, almost all of them write about how disturbed they are about the quality of some defense counsel, and defense counsel who are not providing a zealous, effective representation to their clients. And I've had cases in Superior Court, even when I was in the district attorney's office with Judge Ball when we were both there, when a prosecutor came to me about to start a murder trial and said, the defense attorney's drunk, what should I do? And I said, you have to bring this to the judge's attention. You cannot proceed with this case with a defense attorney who is impaired and you have reason to believe can't provide effective representation. So there's also a big gap there that is in, and again, I know that's not the topic, but if we really want this justice system to work, I mean, defendants have to be well represented. There should be competent counsel and ethical counsel on both sides. So there's a broader issue about what do we do about lawyers misbehaving and ensuring that that defendants in criminal cases receive fair justice and ethical handling. It's a much bigger problem than just allegations of prosecutorial misconduct.
Absolutely. We have our work cut out for us, all of us.
I think you focused on that in your article too. I mean, there was definitely a mention, several mentions in your column about prosecutorial misconduct. I mean, ineffective assistance of counsel. So.
Yeah. Prosecutors, as part of the government, representing the people, wield tremendous power. So we focus on them for this article. So I think at this point, we will open it up to questions from the audience.
Yeah, I'm very curious about the quality of the defense counsel that you're talking about, the appropriateness of their defense, because I'm a journalist for over 40 years, and I've covered a number of these cases where wrong people have been convicted. And it seems like it's always the most vulnerable. You know, the people that are poor, the people that don't have the means, they end up getting a public defender. A public defender is, whizzing around, doesn't really prepare and so forth, and they end up getting convicted when they shouldn't be. So how do we solve this quality problem with public defenders?
Can I just say that I'll take issue with you about the public defenders. In my view, and my experience is completely Massachusetts, the people who are, I'm going to use the word screwed. The people that are screwed are the middle class, who have more money than public defenders, who are not qualified, they're not indigent. Because our public defender's office in this Commonwealth is really good. And CPCS trains people very well. And while in the district courts, people are running around like crazy, you come to Superior Court, by and large, the public defender's office, the public counsel that are full-time CPCS lawyers are really good and really well trained, often better than the prosecutors. And when the people that have some money and therefore they're not indigent, therefore they're not qualified for counsel, have to hire private counsel. And not everybody's as good as Veronica. And there are a lot of people out there who are practicing, getting paid for their work, who, as Diane says, we're all like, oh, yeah, and you find yourself as a judge doing the work for, trying to help the defense counsel along. Because it's the middle people who have to pay for their own lawyers. And I'm telling you, it's going to cost you, who has 25 or 30 grand lying around to deal with, a second offense OUI? I mean, it's going to cost you that much. And those are the people that are hurt. Murders. I mean, who can afford $100,000 or $75,000 for a lawyer, even though you don't qualify for a public defender, a good lawyer to represent you in a murder case? I mean, so that's what I think the bigger problem is the quality of that middle level. As I say, they're not all as good as Veronica. Do you think I'm right on that?
I don't know what you're talking about.
They're not all as good as you.
I don't know what you're talking about.
I would hire Veronica.
All right, let's move on. Right here.
Just coming over with a mic.
Thank you. I'm somewhat disappointed by retired Judge Ball's sort of wishy-washy watering down of misconduct and intentional misconduct. For example, in the case of Bernard Baron, we have the clear case of Berkshire District Attorney actively, knowingly, willfully, consciously concealing videotapes for years and years and years and stonewalling the defense through the original trial, through the appeal and the appeal and the appeal. And the only reason the tapes were actually discovered is because he got a heart attack and died, thankfully. And Judge Ford, who was the other prosecutor at the time, he's now a judge, and there has been no deterrence, no punishment, and all the judges in the Massachusetts bench are perfectly happy with him still serving as a judge. So in terms of willful, intentional, conscious misconduct, which has been proved, we still have no punishment.
Okay. Well, with all due respect, I actually know something about that case. And what happened in that case was that when it went up on appeal by, John Swanley is a wonderful defense attorney, by his attorney, after the now judge had left that DA's office and gone on the bench, the DA's office goes through the files and they said, we don't have any evidence that these tapes were turned over. It went all the way through the appellate process, and a new trial was granted Bernard Barron. That was at the height of the Phil's Acre, that kind of child sex abuse. Wow, what a mess all those days were. The DAs, it went through a new trial was allowed and through the appeals court. Eventually, the Judge Ford, was referred to the Board of Bar Overseers. He hired a lawyer who went to the DA's office and said, let me see the files. The defense lawyer went in and found in the files a letter to the defense attorney saying, enclosed, please find these supposed hidden tapes. So the fact of the matter is there's direct evidence that, as Judge Ford has always said, he did turn it over. So that was discovered after Barron got a new trial. I'm not saying Barron didn't deserve a new trial by any means. And then part of the new trial was granted also for ineffective assistance of defense counsel, but it was in part withholding those tapes. But the fact is that the district attorney's office there, long after Judge Ford left that office, didn't go through the files carefully enough. And the fact is that there is a letter from Dan Ford as a prosecutor to the defense attorney saying, enclosed, please find those supposedly missing tapes. So that's the kind of thing that can happen that appellate case law doesn't necessarily take. There are other ways mistakes can be made. So, I mean, actually
Thank you for bringing it back into the big picture.
Right.
Yeah.
I was just going to actually piggyback on that and ask you a different question about the culture of judges and the culture that you were talking about. And I'm curious, is that culture changing? Is there more of, being more forthright about being involved in prosecutorial misconduct if you think it's happening. And I was just curious, in the cases where you saw judges report prosecutors, what was going on? What exactly specifically was going on that it raised it to a level that you or another judge was taking it to another level?
It's very fact specific. So, I mean, if you see a circumstance where somebody's misbehaving in the courtroom and compromising their clients, representing their clients, that's one circumstance where you might. If you find out during the course of testimony that a lawyer, whether civil or criminal, gave advice to a witness or something to testify falsely or that kind of thing, that would be a circumstance. But it's difficult to generalize about these things. Certainly if you found that a prosecutor, in this conversation, had knowingly, had time after time after time committed, gone over the line in closing argument and after being reprimanded still didn't change it, that would be a circumstance.
On that note, we are going to take some questions that were submitted via RSVPs now. So Lisa from Pride's Crossing asks, how can assistant district attorneys be more effective in challenging unethical, self-serving actions of a district attorney when at present nearly all feel their only options are to ignore it or to find employment elsewhere? Does anyone want to tackle that one?
It's on you, buddy.
I'm not sure if I understand the question.
So with someone from within the district attorney's office feeling as though what's happening is unethical,
Okay.
what should they do?
So it's a situation where you have a prosecutor who sees that the first assistant is withholding exculpatory information about a witness statement, let's say that, for example, hypothetically, and that the prosecutor doesn't want to rat this person out because that would give him a bad rap and affect his reputation. And there'd be a lot of pressure to stay quiet. So what can be done about that? Well, that's a good question, because what's happening is it doesn't have to do with people's egos and people's reputations. It has to do with people's lives, and that's what we're talking about here. We're talking about humanity, people being taken away from their homes and put into a jail cell, an 8x7 jail cell. One of my clients has been serving 35 years in prison, and I've sat with him for hours and hours talking with him about what he's going through. It's a terrible thing to be in prison, especially if you haven't committed the crime. But now I'm
So it
going
sounds like
off.
it sounds
Well,
like
it's now an ethical
finding
violation.
employment elsewhere.
Well, it's an ethical violation. According to the new rule, if an assistant DA, a junior ADA, is aware that exculpatory evidence is being withheld and doesn't take steps to do so, they're on the hook with the Board of Overseers as an ethical
Right,
violation as
under-
much as their superior.
So perhaps reporting anonymously, is that possible to?
I think I think the issue raised by the question is a real and troubling issue, because I think there may be situations where, let's say we're talking about a junior attorney and a more senior attorney, up to the DA. There may be situations where the junior attorney is wrong, but there may well be situations where the junior attorney is right. There's always a risk that a lot of the complaints made about prosecutors, if you were to go through a litany of them, they are all problems and they are all challenges. The issue is, how do the prosecutors faced with them handle them? There complaints about, well, prosecutors are joined at the hip to the police, and so we don't question their representations. We get, prosecutors get worn down by their caseload and stop individualizing their attention to individual cases, let alone the fact that they can't give them the preparation they would like to. So you get a situation, a whole litany of accusations in reality. Although I do want to say, I think I think virtually everyone, even people who write about prosecutorial misconduct, agree that the vast number of prosecutors are very dedicated to doing their job properly. So you've got someone, you're talking about a prosecutor who wants to do her job properly and feels that she's getting instructions, in a sense, that to do something else, not to dismiss a case that she thinks should be dismissed, or even to recommend a more severe sentence than she feels is just and appropriate for an offense. And there really aren't many avenues available. I mean, you can take it up the line, but the reality is, depending on the office, you do risk losing your job. Because all assistant DAs serve at the will of the district attorney. So I would like to see an office where it is top down, where you have the elected official set a culture in the office that all the ADAs should raise issues about ethical concerns when they see them. And they should do this without fear. A number of offices actually have panels where senior attorneys get together. And I think this is true in Suffolk. I think it's true in Essex County. I'm not sure about a number of the other counties, but where when issues are raised, a group of the senior attorneys will get together and really talk it through and see what they feel the appropriate result will be. But if that isn't coming from the top down, I think it's a pretty intractable concern
Systemic.
that is being raised by the question.
My problem is that this shouldn't be, the prosecution should not be policing themselves. There needs to be an independent body.
Well, there is the Board of Bar Overseers. The question is, how are they handling allegations against prosecutors? Prosecutors are lawyers like all the other lawyers in the Commonwealth, and there is a disciplinary body.
And that disciplinary body is not doing enough.
We're going to move on to Karen from Concord, who asked, wouldn't prosecutorial decisions be fairer if prosecutors were not hired directly out of law school and instead were older with more wisdom, perspective, and experience?
Sure, you want to get paid 35 grand after 35 grand a year, right? You know,
Okay,
after.
so that's what we're talking about. So is that 35,000 a year?
I think
Is it
it's
starting?
what's the starting-
It was 38, and I believe it's just gone up to 45
In DA's offices.
in DA's
And you're getting out of
offices.
law school with, $150,000 in debt, and you know what I mean? And if you're, and then you go and you work in, I know people who have gone back to be ADAs, but it's a matter of pay scale. Yes, in a wonderful world, talk to the legislature about paying DAs and defense attorneys what they deserve.
Right, absolutely.
I think we'd have time for another one. So Ira from Newton asks, in situations where one's acts ruins lives, there are often criminal or debilitating civil prosecution of, there are not often debilitating criminal or civil prosecution of the wrongdoers. Why not? So I'll summarize, why no prosecution of prosecutors, I guess, is what this person is asking.
Immunity.
Well, they could overcome qualified immunity with a deliberate act of malfeasance,
Yes, but you have
of
to
committing
prove that.
a fraud upon the court.
Right, but you have to prove that, and that's a pretty difficult thing to do. And the avenue is
Explain this for
usually-
our audience when you talk about immunity.
Well, you can't, for example, you can't sue the governor. You can't sue state actors, people representing the state or the DA's office or so on, for negligence. Otherwise, the entire government would collapse. If every time there was a car accident because a traffic light went out, you could sue, the city. Everybody would be impoverished. So every state in the country, and including the federal government, has sovereign immunity. And the only way around that is to prove intentional misconduct. So it's very difficult to prove intentional misconduct, and they can, really at best, they can show negligence, and there's immunity for that. Now, there are a lot of federal cases. A lot of people have been very successful. You had any? Yeah, Rosie Scapiccio has been
have
very
one right
successful.
now.
You've got one right now, where you can sue police departments for example, for specific acts and so on. So that's what they're looking for, is money for these people in some pathetic attempt to give some small amount, some money that of course can't make up for taking 25 years out of somebody's life. But you're gonna pursue as a civil lawyer the deep pocket, because some DA who's been making 40 grand a year is not gonna have too much to win. You can get a judgment, but you're gonna get it paid. It's just much more useful to go after the parties that can be held liable in the context of the sovereign immunity laws.
Okay.
Did I make myself?
I think that makes sense. One more question from here, and then someone will let me know if we have time for a few more audience questions. So Trevor from Brighton asks, are there types of prosecutorial misconduct that are so pervasive as to go largely unnoticed?
Ooh.
And what are they, if so?
Well, I'm a little confused by the question. The ones that, the worst type that may never be uncovered would be knowledge of and failure to disclose exculpatory evidence. And again, that's because that can be hidden. It may never, you may never know it's there.
I think what he's
The
talking
most
about
common type
is
is
something that is so ingrained in the culture. If I had to guess, so pervasive, so a part of the culture that they go largely unnoticed.
I don't think so. I mean, I think the most common thing are inappropriate statements and closing arguments. That would be my guess, that that's most common. And those do get noticed, though, because they're public. Nothing else comes to my mind in terms of anything that would be, just pervasive, accepted, and not commented upon. I don't know.
I would add to the category, to that, the failure to, dot every I and cross every T about making sure you have all of the written discovery, all of the police reports, everything that the defense is entitled to, and making sure you have it and not just taking the police officer's word for it. And I think that that's a basic duty of every prosecutor, is to make sure that Viranga gets all of the discovery.
Okay. That is all the time we have. Thank you.
A producer of reality TV said this is a perfect formula. Find loud, obnoxious, competitive people and put them in a room and make them fight for a prize that they would kill their mother for. That's exactly what we have in the campaign, and that's why Donald Trump is so successful.